Morning. We're very fortunate and honored to have the great Alexander Rufus Isaacs with us this morning. Thanks for joining us.
Good morning, Warren.
Just a bit about you. Alexander is a British colleague of mine. Went to Oriel College, Oxford, studied modern history, began his career as a barrister. After trying 50 cases in the UK, came out here, moved to Los Angeles, and was admitted in 1988. Alexander, you're presently the secretary of the Beverly Hills Bar Association.
I was last year. We have a leadership ladder now. I think I'm the second vice president. They basically get at least 4 years of out of you before you get the good job.
Congratulations. And
thank you.
What's your position? You're in BAFTA. You're the director or secretary at the moment?
I was on the executive committee at BAFTA, and I was the secretary for a while, and I was on the board for 8 years, but now we have a policy there of, term limits, and so I'm just a regular member of BAFTA now. And
your practice is primarily entertainment law, libel and defamation cases, is that right?
That's pretty much right, yeah. Probably half of what I do is hourly fee litigation, mostly in the entertainment industry. The other half tends to be more contingency related, defamation, privacy type torts.
Well, I was really keen to talk to you because I saw about your involvement with the Johnny Depp case. I'm a lowly family lawyer practicing family law and divorces. And so the Johnny Depp case, as I understand it, was primarily about defamation in the UK. Is that correct?
Yes. An article was published in The Sun in 2018, and it essentially stated that Johnny Depp was a wife beater, and he sued the journalist who wrote the article and the publishers of The Sun, which is News Group newspapers, for libel in the High Court in London.
I'm interested in the case for two reasons. One is, it seems to me, and I've read the decision and I've read some of the transcript. It's really a primer on the law and facts of domestic violence. It's a very good, the attorneys or lawyers in that case were outstanding barristers who examined Johnny Depp on whether or not all these various incidents of domestic violence were actually true. And secondly, I was interested because of your involvement and the way that they took witnesses virtually. They allowed witnesses in Los Angeles to testify virtually. So I was wondering, maybe we can chat and if there's something we can learn from how to do a virtual trial. How did you get to be involved in this case?
I spend quite an amount of time in England. I'm normally there 2 or 3 times a year. I know a number of folks in the London media firms, and one of those is a good friend of mine called Louis Charalambous, who is a partner at Simons Muirhead. And Louis and I had dinner probably about a year ago when he was in LA, and he mentioned to me about the case. And then in around, I think, February of this year, 2020, he called me and asked me if I would help them out with essentially getting some subpoena type orders, compelling some local residents to testify at the trial.
How many deponents did you have in Los Angeles?
Well, we didn't take any depositions, so you use the word deponents. We had, as far as witnesses are concerned, there were probably around a total of 20 witnesses who testified remotely from Los Angeles directly into the High Court in London. I had to get subpoena type orders in federal court under 28 USC 1782, but 2 of those witnesses who were reluctant to attend. But yeah, it was video testimony was a big part of the case.
Was how easy was it to get that order from the federal court in Los Angeles?
Um, the basic criteria for 1782 orders are fairly clear. There has to be a foreign controversy. There has to be an order directed to a local resident, and it has to be made by someone who's interested in the foreign proceeding. So those are quite broad parameters. And to tell the truth, I wasn't entirely sure whether the central district judges here in Los Angeles would want full briefing on the applications, or quite how it would work. And so my initial action was to file an application under 1782, and I put in the conclusion that it was to the effect of, expecting the court to set a briefing schedule so that if the witness objected to the order, they would have a chance to be heard. And I guess then the judge would make a determination on the merits. But I was actually quite surprised that in response to my application, the judge simply granted the application and issued an order. Then it was a question for the witness, who was somewhat taken by surprise by this, filed a motion to quash the original order. And that's when we had some fairly extensive briefing on the issue. And eventually the motion to quash was denied, and the original order stayed in place, and the witness was indeed required to attend on a date and a place to testify.
What was the substance of their objections? Why? Was it money, or they just were inconvenienced?
No, I mean, there were a number of different objections, and I think ultimately it's...
I did wonder about the dog.
There's one of your research assistants has found a case, I believe. But there was a safety concern. We're talking, this was all going down, during, the summer lockdown. And we had to go, we meaning my clients and the Beverly Hills Bar had to ensure that the environment was safe for the witnesses to attend and testify. We chose the Beverly Hills Bar Association as the location. As we spoke earlier, I'm involved with the bar, and the bar's got some really good technology. And so they set aside a room which was used for 2 solid weeks for all of the various witnesses to attend and to testify. After each witness had testified, we had cleaners on site who would clean and sanitize the area where the witness had been sitting, sanitize the exhibit books, and so on and so forth. And so we did everything we possibly could to minimize the risk to the witnesses. And my position to the judge was, this is no more risky than going to your regular supermarket. And so far as I know, we had no health issues at all, and everything went off fine. The other objections that this one particular witness had was she didn't want to be involved because she thought it would be harmful to her career. And she was a celebrity makeup artist, a very well-regarded one. And her counsel made the objection on the basis this is not simply something she did not want to do. She did not want to get involved in this because it might adversely affect her career. And one can understand that the allegations of domestic violence were extremely serious, and people by and large don't want to get involved in such disputes.
Alexander, do you want to briefly tell us a bit about the legalities of the case? Because the libel laws in the UK are very different to the libel laws in the US. And I'm a family lawyer, so I know very little about this. And I was curious why they had this case in the UK. Why not have this case in the US?
Well, that's a very good question. The UK, or I should say more specifically England and Wales, are regarded as being plaintiff friendly for defamation purposes. And the law on defamation, and particularly the procedures, are evolving very rapidly, and I'm doing my best to keep up with them. But essentially, the most important element is the burden of proof. And you could say, and the attorney fees issue as well. But on the burden of proof, if you were to file a defamation suit in the US, in any state in the US of A, you as the plaintiff would have to prove the elements of defamation, which is a false statement reflecting, adversely affecting your reputation and causing you damage, or in some cases it's presumed damages, but you have to prove the falsity of the statement. So if the allegations that were printed in the Sun, I alluded to earlier, were printed in the US, Mr. Depp would have to prove, the burden of proof would be on him to prove that he was not a wife beater. He would bear the burden of proof. And indeed, he filed an action in the state of Virginia against his ex-wife, Amber Heard, and I think also against the Washington Post because of an article that she wrote, not even naming him by name, but alluding to the fact that she was a victim of domestic violence. So in that case in Virginia, Mr. Depp will bear the burden of proving that the allegation that he's a wife beater is false. Now in the UK, that is not the case. There is a defense of truth, and that burden lies on the defendant. So the burden in this particular case in the English High Court was on the publishers of The Sun, on News Group, to prove that what they had printed was true on a sort of balance of the probabilities type of standard.
And the end result, the Justice Nichols decided that specifically 14 incidents of domestic abuse did in fact take place, which I think is being appealed right now.
It is, but I think it's a very difficult case to appeal because the appellate courts in England, just as in the US, tend to leave it to the trial courts to make determinations of fact and credibility. They will obviously check that the trial judge got the law right, but there wasn't an awful lot of law in this case. I mean, or what there was, there's nothing particularly, I think, controversial from as far as any points of defamation law are concerned. And as an indication of that, both parties in London had as their primary counsel criminal QCs, not libel QCs. Both sides had libel QCs who were in court and part of the team, but most of the examination and cross-examinations were conducted by these very senior criminal silks, because that's sort of the way it was viewed. It's a he said, she said situation with all these various witnesses coming in and, giving their evidence as to on these various 14 incidents. And there wasn't an awful lot of law involved. It was very fact-based.
One of the things that was interesting, and we kind of have talked about this before, is that instead of having a direct examination of the witness as we would do in a California court, the witnesses provided most of their direct via a witness statement. Can you explain that? And
yeah, I mean, I would preface everything by saying that even though I'm admitted as a barrister, I haven't practiced English law since 1987, and I kind of keep up with it. But nevertheless, my London colleagues had to, explain to me how the system worked, and I still don't, I think, have a perfect grasp on it. But yeah, my understanding is that basically it's a time-saving device. Each side's witnesses, persons who they would ordinarily call as to examine them in chief, witness statements are prepared for them by the lawyers and are submitted to the other side and to the judge, and subject to any objections, they are admitted into evidence. And then the other side is given an opportunity to cross-examine the witness. So essentially what it means is it's a written examination in chief, and there is no oral examination.
Does the party that called the witness and provided the witness statement then have a chance to rebut via cross-examination, or do they have to rebut using a direct examination? Do you know?
Well, there's a re-examination. Basically, the one party submits the statement, the opposing party cross-examines the witness, and then the original party who had submitted the statement gets a chance to do sort of redirect and to do the rebuttal there.
It's interesting. I mean, we used to have a fairly similar system in family law, and it's actually sort of come back recently. I recently did a couple of cases where we relied upon the declaration subject to cross-examination. So it does, but I was surprised that the case went on for 15 days. That seems a terribly long time to devote all those judicial resources. And I understand that the High Court used up to 5 courtrooms to try the case, that they would do that at the height of COVID. Is that typical, or is that unusual?
Yeah, it was a subject of some criticism, where a number of people saying, why did the High Court give priority to this case when there are other, quote, more deserving cases out there which should have been given priority? And I think perhaps the reason, and I'm kind of speculating here, is that Mr. Justice Nichol, who's the trial judge, is a very experienced in all aspects of media law. He wrote one of the main treatises in English law on media law. And I think probably his point of view that people's reputations needed to be either, the rulings needed to be made soon, because, your reputation is something of great importance and can affect things on a very time-sensitive basis. And as we indeed saw, as soon as the verdict came out, Mr. Depp was removed from a very lucrative film series that he was slated to appear in.
It also shone a light on the issue of domestic violence. So that was, I would say that was pretty important in a public policy sense. I want to get back to the mechanics of doing the trial. Did the order from the federal court, did it simply allow the witnesses to testify or compel them to testify? Or was there, did it set down in some detail how they were to testify and what procedures were to take place?
The federal judges who issued the orders were both very clear that the actual substance of the cross-examination, any objections or of a substantive nature, were to be dealt with by the English court and by the English judge. The orders that were issued out of the Central District were much more about the conditions of the testimony, the amount of time, the place, the various conditions, who could attend and be in the room. They were more concerned with those sort of issues.
Were you given, either by the English court or the California court, a time estimate, and how did you organize the appearance of the witnesses, if there were 20 witnesses from Los Angeles testifying?
Well, we had a timetable. Mr. Justice Nichol, I think, agreed to allow video testimony even before the lockdown hit in March. I think he had already indicated that because there were such a substantial number of witnesses based in Los Angeles, it was not practical to require them all to fly over to London to testify, some for relatively short periods of time. And so I think in principle, the decision was made fairly early on that video testimony was fine, and let's simply figure out the best way to do it. And that was, we had the logistics were less of an issue. The way it actually worked from a timing point of view is Mr. Justice Nichol kept a fairly tight timetable, and same way that one has in federal court, much more so than in state court. You're given specific time limits. And, by and large, I think we kept to it. Most of the testimony from Los Angeles, because of the time difference, was scheduled for the afternoon sessions in London, starting 2 p.m. London time, which is 6 a.m. Los Angeles time. And so people had an early start, but we were done by 5 p.m. London time, 9 a.m. LA time. So people had to get up a bit early, but it wasn't really that intrusive. I think the real problem was that on one occasion, for reasons I'm not quite sure of, the LA witnesses were scheduled to testify in a morning session beginning 9 a.m. London time, 1 a.m. Los Angeles time. Luckily, I was not required to be there that day, but I spoke to the guys who were there all day, and they were, we haven't done things like that since we were, young men and staying up all night enjoying ourselves. But
how many witnesses did you have each day? Because I would imagine, it was probably you had to mitigate because of safety concerns. How many witnesses would be waiting for their turn at the Beverly Hills Bar Association? How did you handle that?
We had a waiting room, and as far as I know, everything went fairly smoothly, and we scheduled 2 or perhaps 3 witnesses per session. We had a pretty good idea how much time it would take, and people were moved along by Mr. Justice Nicol if they were taking too long. And there's always things come up, but by and large, I think we kept the timetable pretty well.
What platform did you use? Was it Zoom?
No, it wasn't. It was a video link that was organized by the High Court in London, by their IT department. And when one was sitting in the main conference room at the Beverly Hills Bar, which is where this was all set up, there was a very large screen on one wall, screen being, I don't know, maybe 10 foot by 12 foot. And in the room, there were set out tables for the witnesses and then tables set well apart for counsel. And you could see on the screen, one of the courts, you correctly said that there were 5 courtrooms being used in London because of the public interest in the case. We would only see one of the courtrooms, which is where the main lawyers were sitting. We couldn't actually see the judge because the camera was placed on the bench next to him, but we could hear him. And, then the other lawyers and members of the public and the press were sorted into 4 other courtrooms in the Royal Courts of Justice. And
so when the witness was testifying, you could only see, what could you see in the UK courtroom?
Well, you could see the whole courtroom. You could see both counsel for both parties, and you could see an inset in the screen of the witness testifying, what they looked like when they were testifying in Los Angeles, so they could see, how they came across. But that was only a small window on the top of the screen. Otherwise, you could see the big courtroom in great detail.
So the camera was placed at the front of the courtroom, facing the lawyers, so the witness could see the lawyers cross-examining them. Yeah,
it was set very close to the judge. So it's really, you're giving it the judge's viewpoint. I mean, this is interesting, and what I always thought was interesting, not so much about the Royal Courts of Justice, because there is less height differentiation. But I remember from my days as a barrister at the Old Bailey, which is the Central Criminal Court in London. These courtrooms were designed, and there is a tremendous height difference in that the judge's dais or bench is very high up and far above the lawyers who are really down in that well of the court. And the only person who is on the same level as the judge is the witness. Is the defendant, is that the dock is on this, also raised very high up at the other end of the court. And so there you have the judge and the defendant, basically on eye level to each other, and everything else is taken down below. And it's quite intimidating. I mean, the guys who designed these courtrooms were ecclesiastical architects, and there's something almost of a sort of Hammer film sort of atmosphere in some of the old Crown Courts. But anyway, legal architecture is not why we're here today, is it?
No, but it's very interesting. How did you have an IT specialist set this up with the High Court, or were you in country? Oh, you had.
No, the Beverly Hills Bar's got IT people. So Jose, who's one of our guys, was great, and he handled everything. He was there for every minute of the testimony, and he was talking a lot to the guys in London, and they worked absolutely seamlessly. So, like I said earlier, even though this decision was made to use video testimony before the lockdown, it turned out to be obviously a very effective way of handling things because of the social distancing we're able to employ with all of these 20-odd witnesses who didn't have to A, go to London, and B, actually go into a physical courtroom.
So I'm not going to ask you anything about internet speeds or protocols or anything like that. Unless you want to volunteer that information. So what advice would you give? I mean, if you do one of these again, either you handle witnesses in LA, or you have a trial in the UK where you're calling American witnesses in the UK. What kind of lessons did you learn from doing a virtual trial?
Well, I think it works very well. I think a lot of us have reservations about video testimony. And I mean, I have reservations, or have had reservations about, for example, video mediations, where I'm going, oh no, you want to do all this in person, and like video depositions, you want to be I want to be in the same room as the witness so that I can get a read on their facial expressions and make sure there's no monkey business and all of this. I think these are ungrounded fears. I think that one of the effects of the pandemic will be to make video depositions, video trials, and video mediations much more common. People are more confident now about using these tools. They're less suspicious about funny things happening in the background. And so long as you've got the good technology involved, it works very well. Obviously, one issue that you have to really focus on are the exhibits. And in this particular case, in the trial, even though all the exhibits were digitized and were available digitally, nevertheless, the London lawyers sent us the complete bundle of exhibits in 3-ring binders. I think there were like 9 or 10 big black 3-ring binders sitting on the table at the Beverly Hills Bar next to where the witness was testifying. And the barrister in London would say, Mr. X, please look in binder 3 and go to, page 48. And so, in the same way, I feel in depositions, it's an issue as well. It's handling exhibits is the most challenging aspect, and something one just has to think about and deal with. And it sort of slows things down a little, but it's manageable.
Yeah, it seems to me, I mean, I've had conversations with my colleagues about this, and whether or not when they're using Zoom or a similar technology, they should have, you can have the exhibits on the screen, but then there's issues as to whether you can see the exhibits correctly and who controls the exhibits. It does seem that having hard copies of the exhibits, both in the courtroom and where the witnesses are, makes more sense. And it's easier than doing it electronically.
I think it's fairer as well, because you may only be shown a portion of a document on the screen if you're just doing everything digitally, and you may not be able to just thumb through it quickly and read the other pages as you would in a normal circumstance. You've got a hard copy. So.
And I did note during one of the transcripts that everyone was fishing around for an exhibit, and they mentioned exhibit 8A, and it wasn't 8A. So, I mean, that's a pretty typical problem, isn't it? That when you have a lot of exhibits. What about breakout sessions? What if you wanted to? Was there a capability for to speak for witnesses to speak to their attorneys? If there, how did that work? If there was, for example, a privilege issue and they made an objection, how did that work?
Well, this was a subject of some discussion when we were arguing about the 1782 orders is that counsel for the witnesses in both cases wanted to be present while their clients were testifying. And, we had some discussion about that. I mean, in a regular trial, if, you are called to testify in a trial as not as a party, but as an impartial witness, do you bring a lawyer along? I mean, in most cases, no, you don't. But the counsel in this case made the argument of saying, well, what if my client is shown a privileged document? And in those circumstances, counsel for the parties isn't necessarily going to make an objection. And that's why I need to be there to make that objection on behalf of my client. And we, frankly, I took the position of saying that's a little far-fetched, but yes, indeed, that turned out to be the case. On one of the witnesses was, in fact, the witness who, one witness who had her witness statement admitted into evidence in the way we discussed earlier, and who was then cross-examined by the defense counsel, and then plaintiff's counsel showed her an email which appeared to have been written to her by her Los Angeles lawyer. And the Los Angeles lawyer was there present in the room at the Beverly Hills bar and got up and basically stood next to his client and made an objection to Mr. Justice Nichols, saying, Malad, this appears, I don't think he called him Malad, but he should have done. My client is being questioned about a document that appears to be a privileged communication between myself and her, and that's entirely inappropriate, and I object on that basis. And it turned out that, in fact, unbeknownst to him, his client had forwarded this email to Mr. Depp's lawyers, thereby destroying any attorney-client privilege.
Oops.
This is the kind of thing you're up against, but that was the sole instance where, I saw that there was really any need to have a lawyer in the room, and it turned out to be unfounded because this client had waived it, privilege.
Now, I noticed that there were fewer objections during the trial than you would expect in a California state case. Why was that?
I think it's the English tradition of, first of all, the barristers have been cross-examining witnesses, if not on a daily or a weekly basis, then at least on a month. They've been trying cases on a regular basis, for their entire careers. So once they've been doing it for 20 or 30 years, they're pretty good at it. And they know what questions to ask, and more importantly, what questions not to ask. And I think the approach to cross-examination is slightly different in England, is that it tends in England to be much more, we say, vigorous. People are basically given a much tougher time in the English courts than they are here. And that's because the object of a trial is certainly said to be to get to the truth of the matter, and that if it requires being hard on a witness, then so within reason, the English tradition is you allow that. You will see how somebody reacts to being cross-examined in a very vigorous manner. And in some occasions, they stand up to it, their credibility is enhanced. And in some instances, they, perception is that maybe they're not being entirely candid about the matter. And the only way really to test that is by this process of cross-examination. I did once, I hasten to add, I had a wonderful telephone, which unfortunately I no longer had, and it had a red button and a green button. And when you were talking to somebody on this phone, if they were telling the truth, the green button would light up. And if they were lying, the red button would light up. But since it only cost $15, I wasn't entirely confident.
I think British intelligence, MI5, uses the same telephone. One other, this might be a bit technical, but The witness statements, once they were cross-examined, did they redact any of those witness statements to remove any hearsay or inadmissible evidence? Do you know?
No, I mean, hearsay, it doesn't seem to be a favored objection. Because these are bench trials, it really, the English approach seems to be that the judges are more concerned with the weight of the evidence than the admissibility. And they take, they will be able to see after their many years in the law, if a witness is giving hearsay evidence, they're going to give less weight to it. They may not exclude it completely, but they're going to be certainly more skeptical about it. So, it's a more practical sort of approach, which is in some ways the English way. We prefer not to legislate for things. We prefer to leave it to experience and intuition and judgment. Yes,
I noticed the decision itself was incredibly long and well written. It was sort of 120, 130 pages. I presume that's quite unusual. And it was because it was such a complicated fact-driven case, and it was the possibility of appeal was very high. So he wanted to cross all his T's and dot all his I's.
Yeah, I mean, if you think about it, it's like, we're talking about a trial judge, not an appellate judge. And you think about the amount of time it must have taken him to have written that. I mean, at least probably a couple of months, like without doing much else. And you could not expect any trial judge in this country to be able to devote so much time to such a detailed written submission, could you? I mean, you get it in arbitration sometimes, but regular judges just don't have that sort of bandwidth or don't have that sort of time to do those things. In London, I guess they adjust the judge's calendar accordingly and know that if he's writing a very long opinion, his clerk knows not to schedule any cases during that time. And so he's able to sit there and devote himself to reviewing all the evidence, going through it incredibly carefully, picking out the salient points, and coming up at the end of the day with something that's an incredibly persuasive document. I mean, I'm very impressed with the work product. It's an incredibly well-written judgment.
Would it be something that he primarily wrote himself, or did he have assistants from clerks? Yeah.
No, there isn't, unless things have changed since my day, there is not a tradition of young lawyers going in and clerking for judges in the High Court.
And is that true of appellate judges in the UK as well as trial judges?
That's correct. Yeah, they don't have young lawyers. It's never been done.
Interesting. Well, this has been fascinating. We've covered ecclesiastical architecture and the pros and cons of virtual trials. So I really appreciate talking to you, and it's been a pleasure. Thanks very much.
Well, thank you, Warren. Thank you very much. I'm very flattered you asked me, and it's been great talking, and appreciate your interest.
I'm going to press the dog is quite my research assistant now in the garden.
Good.
Digging up a bone.
Good.